Interlocutory order. In this video, we will discuss regarding interlocutory order of CPC, that is Code of Civil Procedure. In Code of Civil Procedure, which orders are interlocutory and which orders are final, there is a distinguishment between interlocutory order and the final order or judgment. Now, what's the difference between the interlocutory order and the final order? Final order is basically appealable, but interlocutory order is interim order and it is most of the cases non-appealable unless it is categorically mentioned under some provisions of CPC. So, we will discuss regarding interlocutory order in this video. Now, what's the meaning and definition of an interlocutory order? An interlocutory order is a provisional or interim order passed by a court during the pendency of a suit or proceedings. So it's an interim order and passed by a court during the pendency of a suit or proceeding. So it's an interim order passed by a court during the pendency of a suit or proceeding. It does not finally decide the rights of the parties concerning the main subject matter of the lawsuit. So it is not dealing with the main subject matter of the lawsuit. Its primary purpose is to regulate the proceedings. Its primary purpose is to regulate the proceedings, preserve the subject matter in dispute, to ensure that the final judgment, when passed, can be effectively implemented. So this should be understood that interim order or interlocutory order is passed for the case to continue the case. The order is passed. In simple terms, an interlocutory order to manage the case until the final verdict. Interlocutory order is passed to manage the case until the final verdict. Now the key characteristics of interlocutory order. Interlocutory order key characteristics. First characteristics of interlocutory order is it is not final. It is not final. The judgment is final and judgment is appealable, but interlocutory order is not the final order. It is interim order. Suppose the interim maintenance in a divorce case, that is an interlocutory order. That is not a final order. Whether the divorce will be given or not and what will happen in the case, that is not the final verdict, but it is an interim maintenance is an example of interlocutory order. It is not the final order. And it is provisional in nature. It is temporary and can be modified, varied, or vacated by the court as circumstances change. So it's a provisional in nature. It can change depending upon the case, depending upon the situation. The interlocutory order may change. Now, auxiliary to the main suit. It is the interlocutory order is the auxiliary of the main suit. It helps the main suit to march forward. It aids the proper adjudication in the main disputes. Governed by the specific provisions, the CPC contains specific provisions, that is Order 39 of temporary injunctions, under which such orders are passed. So there are some specific governed by some specific provisions and regulates procedures or preserves rights. Interlocutory order regulates procedures and preserves some rights. It deals with the procedural aspects and prospects of the rights of a party pending litigation. As an example, preserving property, observing discovery of documents, ordering discovery of documents. So these are the some special characteristics of interlocutory order. Another thing is common example of interlocutory order under CPC, that is temporary injunction. As per Article 39, Rule 1 and 2, temporary injunctions is an example of interlocutory order, appointment of receiver as per order 30, as per order 40, order of receiver. As per order 40, order of receiver, that is also an example of interlocutory order. That is commission for evidence. Commission for evidence. As per order 26, issuing of commission to examine a witness or record evidence. That is order 26. And order 6, rule 17, amendment of pleadings, allowing or disallowing changes in the plaint or written statement. Now, adjournment of hearing. Adjournment of hearing. Granting or refusing an adjournment is an example of interlocutory order. Interim maintenance. Interim maintenance in matrimonial or family suits. Ordering payment for maintenance pending for final decisions. In this case, interim maintenance, I previously told that it is a very good examples of interlocutory order. So, another good example is attachment before judgment. Attachment before judgment as per order 37, as per order 38. Attachment before judgment as per order 38. Here it is a good example of interlocutory order. That is, some properties are attached and it will help for the final judgment. And security for cost as per order 25. Ordering a plaintiff to furnish security for the defendant's cost. This is also an example of interlocutory order. Now, how this interlocutory order is different from the final order? So, interlocutory order is temporary in nature, but final order is non-temporary in nature. This is the main thing, and main purpose is regulate the proceedings, preserve status quo. Interlocutory order's purpose is to regulate the proceedings and preserve the status quo. But in case of final order, it conclusively determines the rights of the parties. It conclusively determines the rights of the parties on the same issue. So, the main difference is the purpose. What is the purpose of an interlocutory order? The purpose of interlocutory order is to, regardless the proceedings, preserve the status quo. It basically preserves the status quo of the case, but the purpose of the final order is conclusively determines the rights of the parties on the main issue. What is the rights of the parties in the main issue? The final order deals with that, and final order confers that right to the parties, that you have this right and you do not have this right. So this way final order differs from interlocutory order. Interlocutory order maintains the status quo but never gives us any proper decision. But final order gives the final verdict and it preserves the right of some persons. And distinguish between the main difference between interlocutory order and final order is interlocutory order is interim order and final order is final in nature. And the effect in suit. The suit remains alive when interlocutory and continues. In case of interlocutory order, the suit remains alive and continues. But in case of final order, it is the final judgment and suit will not march forward. It disposes of the suit. Okay, so final order disposes of the suit, but interim order, it helps the suit to march forward. The suit remains alive and it continues. And the nature of interlocutory order is provisional in matter and temporary, and in case of final order, it's conclusive, definitive, and decisive. Okay. Now, appealability. In case of interlocutory order, mostly interlocutory order are non-appealable, but mostly all the orders, final orders are basically appealable. Appealable, and as per section 96 of CPC, appealable. Decrees are appealable. As per section 96 of CPC, we have to remember that as per section 96, all decrees, the final judgments are appealable, but most of the cases interlocutory order are non-appealable, but there are some exceptions. Now we will learn that exceptions, in which case interlocutory order, although it is non-appealable, but in some cases interlocutory order are also appealable. Now let us learn that in which case interlocutory order are appealable. As per section 104, as per section 104 of CPC, and as per order 43, as per Order 43 Rule 1. As per Order 43 Rule 1 and Section 104, this deals with there are some specific interlocutory order which are applicable. Apart from this, there are some other cases also where interlocutory order is applicable. In that case, we have to go for writ petition or Section 115 of CPC, where we can go for revision of order. So there are three ways interlocutory order can be maybe applicable. If the interlocutory order is mentioned in Section 104 or Order 43 Rule 1, categorically it should be mentioned that these are the interlocutory orders which are applicable, and if it is not mentioned, then also interlocutory order may be applicable as per revision Section 115 or as per writ petition of the High Court Section Article 227. Okay, so there are three ways so that interlocutory order can be applicable, and as per Section 96, all the final orders, final judgments, decrees are applicable. So this main difference of interlocutory order and final order is interlocutory order most of the cases non-applicable with some exceptions, but final orders are applicable. And the revision, interlocutory order can be revised as per Section 115, though what I have told previously, that revisional scope is there for interlocutory order. It can be changed in the revision order, Section 115 of CPC, if the lower court exceeds its jurisdiction or acted illegally. When the revision can be applicable if the lower courts exceeds its jurisdiction or acted illegally. If the lower court exceeds its jurisdiction or act illegally, only then the Section 115 is applicable. You cannot apply Section 115 always. If the lower court exceeds its jurisdiction or acted illegally, only then you can apply for this revision. Revision is also possible, but appeal is the primary remedy. Revision is also possible in case of final judgment, but appeal is the primary remedy. Now, appealability. I have previously already discussed the appealability of interlocutory order. Most of the cases, interlocutory orders are non-appealable. Only in some particular aspects, special aspects, some interlocutory orders are appealable, as I previously told, as per Section 104 of the CPC or Order 43 Rule 1. If it is categorically mentioned, only then some specific interlocutory orders are applicable. Now let us learn what specific interlocutory orders are mentioned in Order 43 Rule 1 or in Section 104, and order under Rule 10 of Orders Rule 10 of Order 7. Order 7 Rule 10. Order 7 Rule 10, that is return of plaint. Return of plaint, Order 7 Rule 10, it is applicable interlocutory order. এবং Order 9 Rule 9. Order 9 Rule 9, this is rejection of application to set aside the ex parte decree. This is very important part of this CPC, that Order 9 Rule 9, ex parte decree. You have to remember, ex parte decree, Order 9 Rule 9 deals with ex parte decree, and it can be appealable, although some interlocutory order is passed on the basis of Order 9 Rule 9, as it is deals with ex parte decree, it is appealable. If dependent is absent, only then this ex parte decree is issued and it can be appealable. Order 9 Rule 9, rejecting an application to set aside ex parte decree, rejecting an application to set aside an ex parte decree, Order 9 Rule 9. So this is an interim order, interlocutory order, Order 9 Rule 9, rejecting an application to set aside an ex parte decree, and this is an appealable interlocutory order. And another interlocutory order which is appealable, it is Order 9 Rule 13, set aside or refusing to set aside an ex parte decree. Set aside or setting aside or refusing to set aside an ex parte decree, Order 9 Rule 13. So this is also an interlocutory order which is appealable. Most importantly, an order under Rule 1, Rule 2, Rule 2A, Rule 4, Rule 10 of Order 39. Order 39, that is temporary injunction. In this case, granting, refusing, vacating a temporary injunction or appointing a receiver as per Rule 1, Rule 2, Rule 2A, Rule 4, Rule 10 of Order 39, it is In this case, this case in of temporary injunction, it is appealable. Okay. So, an interlocutory order is not listed, if not listed in Order 43 Rule 1, if not listed in Order 43 Rule 1, as I have discussed just now, these are not appealable, non-appealable. But on some specific categorically mentioned interlocutory order, which are listed in Order 43 as per mentioned in Order 43 Rule 1, then interlocutory order are appealable. So we cannot appeal for interlocutory order, but we can appeal interlocutory order if by using the revisional jurisdiction, that is section 115 of this CPC, or if it is mentioned Order 43 Rule 1, or inherent power, or as per Article 227 of Indian Constitution, as per writ petition of the High Court, interlocutory orders can be changed. So interlocutory orders are generally non-appealable, but there are three exceptions why interlocutory orders are appealable. If interlocutory order are mentioned, some specific categorically mentioned in Order 43 Rule 1, then it is appealable. And in case of revision, if cause goes against the jurisdiction, acts illegally, then we can apply for revision as per section 115 revisional jurisdiction of CPC, or we can apply as per writ petition to the High Court as per Article 227 of the Indian Constitution. So there are three ways the interlocutory order can be amended, or interlocutory order can be appealable. In other case, interlocutory order are not appealable, but all the final judgments as per section 96 of CPC, all final judgments are appealable. Now, key legal principles. Settlement certificate. Settlement certificate. Here there is a case Shaho Babulal Khimji versus Joyben Dikania in year 1981. In this case, the court held that what is the difference between interlocutory order and final order. Final order gives the final judgment, but interlocutory order is never gives the final judgment. It is basically interim in nature, and it helps to maintain the status quo of the case, but it helps to case to march forward, steps to case to continue. But in case of final order, it is the final judgment, it gives the final judgment, and it ends the case. So this is the court holds that it gives the rights and finally decides continuous issues between two parties. It may be treated as a judgment even if in suit continues. Okay, so this explained the scope and applicability of interlocutory order. So in summary, we can say interlocutory order is interim, it is procedural and temporary. Interlocutory order is interim, procedural and temporary. It manages the lawsuit but does not end it. Interlocutory order manages the lawsuit but does not end it. It generally not appealable unless specifically listed in Order 43 Rule 1 of CPC. Okay, and the primary remains against the non-appealable interlocutory order, that is revision of section 115 or invoking writ injunction of High Court. The distinction from final order is critical for determining the correct appellate remedy. So this is the interlocutory order, which is interim in nature, but final order gives the final judgment. So interlocutory order is most of the cases non-appealable, but final judgment is appealable.